Hello all, my name is Neeraj Kabra. I'm an associate advocate at Law Chamber of Siddharth Murarka and I'm the host for today's session. Today we have speaker advocate Aniket Nikam. He will be enlightening us on today's topic, that is law of approver, how to deal with a self-confessed traitor. Now I request advocate Aniket Nikam sir to start with his lecture.
Thank you. Good afternoon, friends. It's a pleasure and privilege both to be here again on this digital platform. Thank you, Siddharth, and your entire team for the inexorable efforts that you guys are taking in arranging these webinars. Well, virtual world is virtually becoming a reality in these times. Court hearings are taking place through video conferencing, and I'm sure many of you must have attended it already. Judges are bid online farewells. Seminars have become webinars, and sitting in the comfort of our homes, we are able to attend court hearings. Here are some brilliant lectures on various branches of laws from the speakers across the length and breadth of our nation. Perhaps this is the silver lining in the dark times of COVID-19. Be that as it may, friends, today I'm going to deal with that interesting facet of criminal law, which permits an accused to go scot-free, despite he being involved in the crime. However, only on a condition that he confesses his crime and also exposes the role of all his partners in the said crime. Today, I will be talking about law of approver and how to deal with these self-confessed traitors. Supreme Court time and again has said that the approvers are somebody who could be rightly called as self-confessed traitors. So therefore, I would be addressing on these issues of law today. I'm aware that several of our viewers would also be law students or graduates or lawyers in their early years of practice. And therefore, for the purpose of better understanding and to put it simply, I have divided my talk. Rather, I would be addressing on 7 issues today. Issue number 1, what do you mean by an approver? Number 2, what is the origin of law of approver? 3, why to tender pardon to an accused who is involved in a gruesome crime and make him an approver? 4, what is the jurisprudence and wisdom behind having such provisions of law? 5, relevant provisions of the Evidence Act and CRPC that deals with the law of approver. Number 6, I will be discussing certain important judicial pronouncements surrounding the law of approver. And 7, as a defense lawyer, how one can shatter the testimony of this self-confessed traitor. So I would try and address on all these 7 issues within the stipulated period of time. So to begin with, what do you mean by an approver, or who is an approver? An approver or accomplice, let me tell you, is not defined anywhere in the Evidence Act or in the Code of Criminal Procedure. An approver is one who has concurred in the commission of an offense. And as I said earlier, that there is no specific definition. Therefore, an accomplice means a guilty associate or a partner in crime, a person who is actively participating in crime. And undoubtedly, as per the provisions of Indian Evidence Act, accomplice is a competent witness. There can be, however, no doubt that the very fact that he has participated in the commission of the offense introduces a serious stain in his evidence, and courts are naturally reluctant, and rightly so, to act on such tainted evidence. An accomplice, by a long established legal tradition, is a particularly infamous witness, one who, being an active participant in the crime, now seeks indemnity, immunity, protection from law by accepting to implicate others. So it's in that sense a shady area, it's a slippery slope, because accomplices are usually interested and always, as I said earlier, infamous witnesses whose testimony is admitted from necessity, it being often impossible without having recourse to which to bring the principal offenders to justice would be a difficult task for the prosecution. And therefore, it is a pro-prosecution provision which has been introduced under the provisions of the Indian Evidence Act as well as Code of Criminal Procedure. However, today I would also be talking about how to demolish the theory of such approvers by relying upon the judgments that I would be quoting. So the mere fact that one had knowledge that a crime has been committed, or that he concealed or failed to disclose such knowledge, does not tender him an accomplice. If, for example, the concealment is due to the witness's anxiety for his own safety rather than any desire to shield a criminal, he would not be an accomplice. To give you an example, suppose A, B, C, D are involved in the commission of offense. Now, E, who happens to be the friend of A, B, C, and D, came to know or he had already a knowledge that an offense is going to get committed. But he does not disclose this to anybody. He keeps mum for the reason of anxiety, for the reason of his own protection. In such a situation, though he could be dealt with under section 39 of the Code of Criminal Procedure, he cannot be prosecuted as an accused in that case, number one. And number two, he cannot be roped in as an approver under the provisions of section 306 or 307 of Code of Criminal Procedure. Therefore, if suppose a witness is trying to conceal a fact, probably because of anxiety or probably because of his own safety, because he is scared from the criminals, from those accused persons. And therefore, in such a situation, such witness cannot be called as an approver. He cannot be put forth as an approver in the courts of law. That's number one. Number two, nor would a person who chooses to remain silent after obtaining knowledge of the commission of the crime can be termed as an accomplice within the rule. So taking the similar example, suppose A, B, C, D commit an offense and E comes to know after the offense has been committed that A, B, C, D have committed the offense. He does not disclose it to the police or to anybody for the reason of his own safety or for being scared or afraid. In such a situation too, such person cannot be roped in as an approver. So it is very essential that in order to be an approver, and section 306 also clarifies that position, to which I will come a little later, an approver has to be privy to or he has to be an active participant in the commission of the offense. That's very important. To render a person an accomplice, his participation in the crime must be criminally corrupt, and rule of prudence requires that the accused who has played the minimal role should be made an approver. For example, in case of theft, if A, B, C commit the offense of theft and the allegations against D that he is also involved in the theft, but his role is that of keeping a watch whether anybody is coming or not. He may be involved from scratch to end. He may be involved from start to end. But though his role is minimal in that sense, in such a situation, the prosecution may, in their own wisdom, if they do not have enough evidence against ABC, they may make D as an approver. So the law says, and there is no provision in IPC or in CRPC or Evidence Act as to which sort of accused is to be made an approver, but the rules of wisdom and also the judgments that have been laid down by our Supreme Court requires that one who has played minimalistic role may be made an approver in a given set of circumstances. And the purpose, therefore, is to bring the principal offenders to justice by seeking help from an offender who has a lesser role in the entire offense, but who knows the details of the offense. It is also important to remember that once the immunity is extended to the accused and the accused is made as an approver, he stands discharged, whereupon he ceases to be an accused and would be examined only as a witness unless the said privilege is revoked on violation of the condition of disclosing the complete truth. Friends, we often come across inventive, ingenious criminals who will devise increasingly sophisticated and complex methods of operation designed to shield their activities and identities from detection by law enforcement agencies. For such kind of accused persons and for such kind of crimes, perhaps law has made this provision of accomplice testimony, which becomes an important tool in the hands of prosecuting agency to pierce the curtain of secrecy that surrounds a particular crime in question. Now, where did this law of approver really originate from? Law of approver has its origins from the common law practices of approvement. Under the law of approvement, a person charged with a capital offense could seek leniency as an approver by confessing his guilt and agreeing to testify against his accomplices. Admission as an approver was discretionary by the court and was limited to only those cases in which the approver was a direct participant in the crime under investigation. The law of approvement, however, fell into disuse by the close of the medieval period. By the late 16th century, a practice known as the crown witness system had evolved in the place of the law of approvement. Unlike the law of approvement, a person turning into a crown witness was not required to plead guilty. Instead, he received in effect a grant of non-prosecution conditioned upon his best effort to assist in the prosecution of his associates or his accomplices. I believe as early as in 1751, English courts instituted a safeguard measure requiring the testimony of a crown witness to be corroborated through independent evidence. our laws, the Indian laws, have adopted this common law system. And even in our laws, there is a requirement that the testimony of an approver has to be corroborated. That's a point that I will come to little later as to what extent corroboration is required, what is the nature of corroboration that is required under the law. But to say it in these words, our laws have adopted common law system of approver, and not just Indian legal system, but even the American legal system is by and large influenced by the law of approvement that existed in the common law jurisdictions. Here at this stage, I think it is little relevant for you to share a personal anecdote with you all when I'm talking on this topic. And I'm reminded of this incident and I vividly remember it. So when I was in class 5th, way back in 90s, and I was a pretty mischievous student back then. So what I had decided was, me along with a couple of my friends, we had decided to trouble a fellow classmate of ours. And what we did was we concealed his compost box. That fellow classmate, he searched for his compost box everywhere, but he was not able to locate it. He was naturally troubled. He was naturally sad, upset. He went to the class teacher and he told her that his compost box is not to be found despite his all efforts. And he expressed his strong suspicion that perhaps Aniket and his friends are involved in that mischief, because we were infamous in that sense in those times, and for all such kind of pranks and mischiefs. So the class teacher had no reason to disbelieve him. And then the class teacher immediately summoned all of us. We were 4 of us. We were summoned and she asked us in her very stern voice, saying that give that compost box to that boy and I'll spare you all. Now we knew, since I come from a family of lawyers, I knew a little bit of law back then. So I had already told my friends, my accomplices or my associates or my partners in crime. And I told them that, look, we might be faced with a situation where they may ask us to hand it over. But since there is no eyewitness who have seen us concealing that compost box, let's not be scared. Let's not betray each other. Let's stick up together and let's stand up together and let's go out and face the class teacher or that fellow classmate, and with a very poker and straight face, let's tell them that we have not done it, we do not know where it is, and perhaps he may be mistaken. So we stuck to that plan of ours and we said we do not know where it is, we have not done it. Now, having realized that her first formula has not worked, the class teacher threw a second formula, and she was an intelligent lady. And I still remember what she said to us. She said, look, if one of you comes out and tells me the truth, I will spare that boy. However, I will ensure that rest all the boys are punished, and I will also inform your respective parents. When she said that, I was a little scared. I was a little petrified, because I thought that she may really go out and inform my parents, because one of us might break. So instead of anybody breaking first, I thought I'll take that chance. I'll seize that chance. I'll come out clean, and perhaps then these things will not go back to my parents. So I came out and I said, well, we have hidden it. We have kept it over there. And I got that compost box, handed it over to him, and bang, I received a slap on my face. I was in tatters. I was startled. I was stunned. I was baffled. I was not knowing what has happened. All those emotions went past by my mind in that 1 second. And that 1 second was not really getting over, perhaps theory of relativity. And I was not able to understand. I was at 6s and 7s as to why this has happened. I agreed to the proposal that the class teacher gave. I came out clean. I said where it is. And yet I was the only one who got slammed. And my fellow friends who were also involved were not even touched. So I was in tears. I went back home. I confessed to my parents whatever happened. My parents again scolded me. They rebuked me. They admonished me. And they said that not to do such kind of things. And I took it to my heart. And hence then, let me assure you, I have not played any mischief on anyone. After some time, my father came to me and in a very humorous tone, he asked me, well, do you know what is law of approver? I said, no, I don't know. Then he said, and I still remember those words. And he tried to explain to me in a very simple language. He said, look, if some boys are involved in a mischief and if they get caught, and if one of them steps out and tells that what has happened, how it has happened and how it transpired, the boy who has come out is the approver and he has to be pardoned. No action has to be taken against him, but action has to be taken against all other persons who are involved. In your case, your class teacher invoked the law of approver, but perhaps she did not apply the principle behind it because you were the only one who got slammed. So that concept of law of approver has intrigued me since then. And when Siddharth asked me on what topic I would like to speak on, this was one of those topics that really came to my mind, and I thought I must share you this little anecdote for whatever worth it is. So moving ahead, friends, why to tender pardon to an accused and make him an approver? Now, one of the most fundamental principles of criminal jurisprudence is that no crime should go unpunished. Natural justice requires that every person who has committed crime or who is involved in a crime must necessarily receive just and proper punishment for the same. While considering the question of punishment, one has also to see the psychology of the victim or their relatives in the matter. This is considered as the retributive theory of punishment, and I'm sure many of you must be already knowing about it. The term retribution means satisfaction of the victim or their relatives that the offender has been properly, adequately, satisfactorily punished by the courts of law. Thus, we find that the idea of awarding punishment to the offender is closely connected with the psychology of victim. However, to this concept or to this theory of retributive punishment, the law of approver in that sense is an exception, because the theory of retribution says that victim or the family of victim desires that adequately all the accused must be punished. However, here is one provision of law which says that if there are 5 accused who are involved in the offense, one of them could be spared, could be pardoned for the purpose of punishing the rest of the accused persons. So, though the retributive theory may demand that the accused who has participated in the crime, each of them must be prosecuted, must be convicted, must be sentenced, to this, approver, the law of approver carves out an exception in the sense that one of the accused is being tendered pardon in the larger interest of justice, on the condition that he makes a true and full disclosure about the crime and also about the involvement of his associates. Now, approver, as I said earlier, is invariably a person who has participated in the commission of crime directly or indirectly. And no doubt he is a guilty person. So people may ask, and by people I mean general public, they may ask, approver is a person whose punishment is very much desired by the victim or his relatives. Approver is a person who has done wrong to the society. Approver is a person who has broken law defeating the ends of natural justice. Approver is a person who accepts before court on oath that he has committed a crime along with some others. Approver is a person who pleads guilty and yet law lets him off. Why? Well, the answer to this is that it is quite profusely clear that court cannot convict any person unless there is some legally admissible evidence against him. Evidence is the only way, my friends, to prove the guilt of the accused persons. The jurisprudence behind turning accused person into an approver is obviously to see that main culprit is not let scot-free simply because there could not be any direct evidence available against him or them. This is perhaps the clear wisdom behind the provisions of approver. The very idea of turning the accused into a prosecution witness is based upon the principle of accepting lesser evil. The reason is that main culprits should not escape from the clutches of law on the grounds of no evidence or deficient evidence. Some jurists call it as a necessary evil, and rightly so. Now, as I said earlier, I would also be discussing about the wisdom behind these kind of provisions in law. What is the wisdom? I believe law of approver is based upon that law of wisdom which says divide and rule. Divide and rule has always been a rule of wisdom, and we Indians know it better since the time of British invasion. In fact, I'm reminded of a famous English maxim, set a thief to catch the thief. Thus, law knows for certain that in case a thief is to be caught, then another thief should be employed for the said purpose, because the ways and means of one thief are very well known to another thief. They are birds of the same feathers, and therefore they flock together. They sail in the same boat, and therefore they know the course of each other. It is a natural instinct of every criminal to commit crime in such a fashion that there shall be no evidence left against him whatsoever. Normally, crimes are committed in dark and in seclusion. The term dark does not mean absence of light, but it means absence of knowledge on the part of others. Crimes are thought of in dark. Crimes are committed in dark. Evidence is attempted to be destroyed in dark. Birth, life, and death of a crime is always in dark. Conspiracies are always hatched in secrecy, and except the conspirators, nobody knows about the nature of conspiracy. Except the conspirators, nobody knows whether the substantive offenses have been committed in pursuance to that conspiracy or not. And in spite of deep and thorough investigation, at times the investigating agency is at not been able to establish or connect sufficient evidence in order to establish the culpability of the accused persons who are charged with a particular offense. Apart from this, there is also practical wisdom that I think that is there behind such kind of provisions of law. The theory of granting pardon is based on this practical wisdom, which says that in case an occasion arises whereunder one is likely to lose everything, then law expects that a compromise should be done with a view to have something at least in the hands. With some propriety, I am reminded of a famous Sanskrit couplet which reads as Sarvanashe samutpanne ardham tyajati panditaha. It means that in case an occasion arises where one is likely to lose everything, then a wise person is prepared to lose half, because thereby he stands to retain at least half. Instead of 100% loss, one should try to have at least 50% gain. This is the principle of practical wisdom. It is on this principle that law incorporates this position. Law desires to secure conviction for the bigger criminal by allowing a minor criminal to go away. It is not that law likes this, but it is only a compromise effected by law on the principles of natural justice, so that deficiency or absence of evidence do not serve as a ground for acquittal of those who are involved in heinous offenses, and therefore it results into compromise of the principles of justice. With this, I would turn to the next issue, which is what are the provisions under the Indian Evidence Act which deals with the concept of approver. Now, as I said earlier, there is no specific definition of approver or accomplice under the provisions of Indian Evidence Act. Section 133 of the Evidence Act, which deals with this concept of approver, says that an accomplice shall be a competent witness against an accused person, and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice. So I'll stop here. What does section 133 says? It says that an accomplice or an approver is a competent witness against an accused. So the competency of an approver as a witness is identified under section 133. With that, the second part of 133 says that a conviction can be validly based upon the testimony of an accomplice, and there is no mandatory requirement that testimony has to be corroborated, because the latter part of section 133 says that a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice. However, after having read this provision, it is also important to read illustration B to section 114. Now, mind you, section 114 deals with presumption about existence of certain facts. And to that section, there is one illustration B, which says that an accomplice is unworthy of credit unless he is corroborated in material particulars. So section 133 says that corroboration is not mandatory to place a conviction on the basis of the testimony of an accomplice. However, under illustration B, it has been mentioned under the Indian Evidence Act that an accomplice is unworthy of credit unless he is corroborated in material particulars. The joint and combined reading of section 133 and 114 illustration B is that according to the former, which is a rule of law, an accomplice is competent to give evidence, and according to the latter, which is a rule of practice, it is almost unsafe to convict upon his testimony alone. And there have been plethora of judgments which have really evolved this law and have said that accomplice has to be materially corroborated only when in exceptional circumstances the court is of the opinion that the testimony of the accomplice does inspire confidence and it is reliable and it is worthy of credence. But it is in extremely small and rare cases can court place conviction on the testimony of an accomplice which is not corroborated. Therefore, friends, though the conviction of an accused on the testimony of an accomplice cannot be said to be illegal, yet the courts will, as a matter of practice and prudence, not accept the evidence of such a witness without corroboration in material particulars. The point of significance is that when the court deals with the evidence of an accomplice, the court may treat the evidence of an accomplice as substantive evidence and inquire whether it is materially corroborated or not. the testimony of the accomplice is evidence as understood under Section 3 of the Evidence Act and has to be dealt with as such. It is no doubt that it is an evidence of a tainted character and hence weak, but nonetheless, nevertheless, it is evidence and may be acted upon subject to the requirement, which has now virtually become a part of our law, that it has to be corroborated in material particulars. And mind you, corroboration in incidental or ancillary particulars is not sufficient. In fact, I will be addressing this issue a little later, where I would be talking about as to what sort of corroboration is required. But please keep in mind for now that the corroboration has to be in material particulars. The cautionary rule of corroboration as incorporated wide illustration B of Section 114 is because an accomplice who betrays his associates is not a fair witness, and it is possible that he may, to please the prosecution, weave in false details into those which are true, and his whole story therefore appearing to be true. Therefore, the requirement of corroborative evidence to show that the approver is speaking the truth with regard to the accused that he seeks to implicate is extremely necessary. Please note that there should be corroboration in material particulars not only concerning the crime, but corroboration of the approver's story by evidence which connects or tends to connect an accused with the crime. Corroboration could be by direct or it could be by circumstantial evidence. However, while looking for corroboration, one will first have to look at the broad spectrum of the approver's version and then find out whether there is other evidence to lend assurance to that version. The nature and extent of the corroboration may depend and may vary from case to case. The defense lawyer can surely impeach the version of such approver on the grounds that it is not sufficiently corroborated in material particulars. And therefore, it is not enough when the prosecution says that there is enough corroboration. The court will have to, when the court is dealing with an evidence of an approver, the court will have to be circumspect, the court will have to be slow in accepting such kind of tainted evidence, and the courts must look for the corroboration in material particulars which corroborates the theory of the approver and stands the test of truthfulness. In a famous English judgment of Davis versus Director of Public Prosecutions, it was held that in a criminal trial, it is the duty of the judge to warn the jury that it is dangerous to convict upon the uncorroborated evidence of an accomplice. And we have seen that even our Supreme Court judgments have adopted this line of approach. The illustration B to Section 114 also requires that there has to be corroboration. Now with this, let me start a small PowerPoint presentation that I have prepared for the purpose of your convenience. And just give me a second, I'm sharing my screen. I hope you're able to see. Devendra, is the screen being shared properly? Yes. So let me start.
Yes,
so when I speak about law of approver, what comes to my mind first is the case of Joshi-Abhyankar killings. If anybody who is watching us today and who is from Pune would know about this case, these were serial murders that were committed in the city of Pune, which happens to be in state of Maharashtra, between 31st of October 1976 to 23rd of March 1977. These accused persons, who were 5 in number, 4 were ultimately sentenced to death and they have been hanged in 1983. The 5th was turned into an approver, and I will come to his relevance a little later. But first, I will address you as to what was the modus operandi of these boys, who were young boys studying, who were commercial arts students doing graduation, and they were on a murder spree. Their usual strategy was to break into homes and they would murder the family members by first stuffing cotton in their mouths and then strangulating them with a nylon rope. In fact, what I was told was that city of Pune was completely deserted in those days after 6 in the evening because people were scared. People were not stepping out of their houses. People were not willing to open their houses to anybody after 6 in the evening because that was the normal time when these offenses were committed by these guys. Now, these gruesome killings had really shocked the entire state at that point in time. And there was no direct ocular evidence available against them. Therefore, perhaps this was one of the early cases where, despite the case being in limelight and in public glare, and there being a lot of public outcry, public anguish against all these criminals, against all these accused persons, and when the public wanted all these accused persons to be convicted, sentenced, and hanged, prosecution in its wisdom made one of the accused persons as an accomplice in this case in order to establish the guilt of all other accused persons, because at that point in time, there was no sufficient ocular evidence available with the prosecution. Therefore, as I said earlier, that theory of retributive demands that all the accused must be punished. In this case, law of approver is an exception. In this case, the prosecution took a daring step in that sense and made one of the accused, against whom also there was a lot of public outcry, made him an approver. His evidence was accepted by the trial court, accepted by the High Court, accepted by the Supreme Court. And on the basis of that evidence, all 4 accused were sentenced to death and they were ultimately hanged on 27th of November 1983. There's one more thing about this case. In the case of Nirbhaya, it was said that all the accused were hanged simultaneously for the first time. Well, that's not true. It was in the case of Joshi-Abhyankar killings that the hanging happened simultaneously of all the accused persons for the first time. And thereafter, it was the Nirbhaya's case was probably the second case in respect of this. Now, this is an image of this famous movie called Maafiचा Sakshidar. Maafiचा Sakshidar also in Marathi means an approver. In this movie, Nana Patekar had acted as the accused number 1. And it's a brilliant movie. It is based upon this concept of approver, and one must watch it if you have not seen it already. In fact, when I was defending Nana Patekar in the Me Too case, I happened to discuss about this movie with him, and he gave me a lot of insights about how he prepared for the role and what information they had got when they were preparing for this movie about this crime. So I thought I must bring it to your notice. So what is law of approver under the Code of Criminal Procedure? Now, if we take a look at section 306, now let me tell you, under the Indian Evidence Act, there are 2 sections, 133 and 114. Under the Code of Criminal Procedure, there are only 3 sections, 306, 307 and 308. Now, 306 says, with the view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offense to which this section applies. So I'll pause here for a moment. So the wordings of section 306 are very clear that the purpose is for the purpose of securing the evidence of any person who is directly or indirectly concerned or privy to an offense. So that is the requirement before one can be really turned into an approver. Number 1. Number 2, the section says that the Chief Judicial Magistrate or a Metropolitan Magistrate at any stage of the investigation, inquiry or trial may grant pardon. However, the later part of the section says that the Magistrate of the First Class, the JMFC, however, can grant pardon only at the stage of inquiry or trial, and no such powers are reserved to the Judicial Magistrate First Class at the time of investigation. So though 306 says that the Chief Judicial Magistrate, the CJM or the Metropolitan Magistrate can grant pardon to an accused at the stage of investigation also, no such powers are reserved for the JMFC at the stage of investigation. The JMFC can grant pardon only at the stage of inquiry or trial. That's number 2. Number 3, the pardon is granted only on a condition that the accused who is turning himself to be an approver agrees to make a full and true disclosure of the whole of the circumstances within his knowledge relative to the offense and to every other person concerned, whether as principal or as abettor. So the purpose of granting pardon is that the accused agrees to come out clean, to disclose all that he knows, right from the hatching of conspiracy, right from the incident that happened, and right as to what transpired thereafter. And he must disclose all these events. Only on that condition the pardon is granted to him. Now, subsection 2 of 306, which is not before you on the screen, says that the court, the magistrate, while exercising his jurisdiction to grant pardon, has to apply his mind judicially and not mechanically. And only on a judicious application of the mind, if the court feels that this is a case where this accused can be granted pardon can be tendered to him, then the magistrate can do so. But it requires that the magistrate must exercise his jurisdiction judiciously and not mechanically. Subsection 4 is important section which provides that a person to whom the pardon is tendered shall be detained in custody unless he is already on bail until the termination of the trial. So the wording of this section is meant to protect those who are agreeing to turn themselves into an approver. Because suppose an accused agrees to turn himself into an approver, naturally his associates, his partners in crime are going to entertain a grudge against him. naturally they would want to eliminate him, bump him off, maybe induce him, offer him allurements so that he does not go the way of approver. And therefore, in order to protect him from all these outside influences, subsection 4 provides that an approver has to be detained in custody until the termination of trial. However, there have been instances where bails have been granted to the approvers even during the pendency of trial. In fact, as recently as in January 2020, Bombay High Court granted bail to an accused who was to an approver because the trial had prolonged and because he had given his evidence and he had stated, he had made a full and true disclosure about all that he had to say, and the prosecutor had no objection about it. And on that ground, bail was granted to him. Moving ahead, section 307 CRPC, now it says at any time after commitment of a case, but before judgment is passed, the court, with the view to obtaining at the trial the evidence of any person supposed to be directly, indirectly concerned, tender a pardon. So 306 applies to pre-commitment stage, 307 applies to post-commitment stage. So after the case is committed by the magistrate, suppose the case is triable under section 302, which is triable by Sessions Court. And after the magistrate court commits the case to the Sessions Court, 307 comes in, and if it is a case in which the prosecution is of the view that pardon is to be granted, then the section 307 will apply, the procedure laid down, which says that any time after commitment of a case, but before judgment is passed. So pardon could be granted to an accused at any stage of the trial, even after examination of several of witnesses, even after the stage of 313, provided that it is done prior to the pronouncement of the judgment. That is the only caveat under 307. And rest, it is for the purpose of evidence of any person who is directly or indirectly concerned in or who is related to be involved in the offense. Now, section 308 of CRPC, an extremely important section. Now, section 308 of CRPC reserves the right with the public prosecutor, the concerned public prosecutor of the trial, to terminate or revoke the pardon that has been granted to the accused on the ground that he is not making a true and full disclosure of all the events. So moment the public prosecutor feels that the true events are not being disclosed by this accused who has accepted the pardon, the public prosecutor within his jurisdiction can issue a certificate under 308, and in such an eventuality, the pardon stands revoked. Now, what is the importance of this? And I would now come to the discussion on certain important judgments related to the law of pardon. And the first judgment that comes to my mind is that of Abu Salem, 2010 SEC. It's a wonderful and excellently worded judgment of Justice, His Lordship Justice R.M. Lodha. And before I tell you what is the law that has been laid down, first I will tell you what were the facts of this case. One Pradeep Jain, who was a builder by profession, was allegedly eliminated by hired gangsters in the year 1995 for not succumbing to the pressure of parting with his landed property in Mumbai. Abu Salem was one of the principal conspirators involved in the said case. And at his instance, the event of murder happened. On 18th of September 2002, Abu Salem was arrested in Portugal. He was extradited and brought to India. And Abu Salem was tried for the offense of murder of Pradeep Jain. He was tried before the special court because the stringent provisions of TADA at that point in time were invoked against him. In that case, there was one co-accused, Riyaz Siddiqui, who was also a co-conspirator and who during the trial expressed his desire to disclose fully and come out clean and bring out all the aspects of conspiracy to the notice of the court on oath. The conspiracy was hatched in Dubai and he wanted to be a approver and bring all these facts on record. So naturally pardon was granted to him. He became an approver, he became a prosecution witness. And when this Riyaz Siddiqui stepped into the witness box, and mind you, I've read the deposition myself. When he stepped into the witness box and when the prosecutor asked him as to disclose the events that transpired in respect of this conspiracy, he maintained a poker face, he maintained a straight face, and he said that he doesn't want to say anything about the conspiracy, and his answer was in the negative. Naturally, the concerned prosecutor issued a certificate under 308. The pardon that was granted to him was revoked, set aside. And after that, the advocate for the co-accused, or rather the co-accused, moved an application to cross-examine that approver on the ground that since an approver was a prosecution witness and since now the pardon tendered to him has been revoked, or rather the prosecution, since he was a prosecution witness and he has not supported the prosecution, he becomes a hostile witness and therefore allow us to cross-examine him in respect of all his earlier statements that were recorded under 164, that might have been recorded under 161, etc. The special court at that point in time allowed that application and permitted the advocate for the accused to cross-examine this approver, Riyaz Siddiqui. To this, the state of Maharashtra took an objection and went to the Supreme Court. And Supreme Court, in this interesting and beautiful judgment, said that once an accused is granted pardon and once he becomes an approver, and when he fails to support the case of prosecution by not disclosing the true and correct events that transpired, which was a condition based on which pardon was granted to him, and if the public prosecutor issues a certificate under 308 revoking his pardon, then the approver gets relegated back to the position of a co-accused and he has to be tried separately, and there is no question of he being then cross-examined by the advocates of the other accused on the ground that he could be treated as a hostile witness. Once the pardon is revoked, the accused goes back to the position, the approver goes back to the position of accused. His evidence has got no value in the eyes of law and it has to be ignored in toto. And that is what the Supreme Court said in this famous judgment, that once an approver is no longer an approver, his evidence has got no value. The lawyers of the co-accused cannot cross-examine him on any grounds whatsoever. The next judgment is Sarwan Singh versus State of Punjab. Extremely important judgment of 1957 of Justice Gajendra Gadkar, a pioneer of personal liberty. And in this judgment, Justice Gajendra Gadkar involved the double test doctrine, which while evaluating the evidence of approver, it said that there are two tests that any trial court has to satisfy before taking into consideration the testimony of an approver. What are those two tests? Whether the approver is a reliable witness and whether the testimony of the approver is corroborated in material particulars. Now, let me give you background facts of this case. In this case, Harbans Singh, Gurdial Singh and Sarwan Singh, the appellant before the Supreme Court, were charged for the offense of murder. The case against them was that they, along with Banta Singh, who later on became the approver, had intentionally caused the death of Gurudev Singh by inflicting injuries on his person with sharp weapons. The trial court sentenced each of them to death. On appeal to the High Court of Punjab, the order of conviction and sentence imposed upon Harbans Singh and Sarwan Singh was confirmed, whereas the order of conviction imposed upon Gurdial Singh was set aside and he was ordered to be acquitted. Sarwan Singh naturally went to the Supreme Court against that order. This was a case, friends, where the deceased was brutally assaulted in as many as 69 incised wounds and 2 contused injuries on his person, which he had sustained because of that murderous assault. Now, in this case, Justice Gajendra Gadkar said that the trial court must ask itself whether the approver is a reliable witness, and by that it means whether his testimony inspires confidence, whether it is coherent, whether it is natural, and if it is so found, then the court has to consider the second test, which is whether the testimony of the approver is corroborated in material particulars. And unless these two tests are considered by the trial court, no conviction can be placed upon the testimony of an approver. Ultimately, Sarwan Singh came to be acquitted in this case. Next, Bhiva Patil versus State of Maharashtra, 1963 Supreme Court. Now, again, before I discuss the principle of law, let me tell you the facts of this case. It arises from the state of Maharashtra. Again, an interesting case, interesting facts. There were 4 accused persons. Rama Patil was accused number 1. Bhiva Patil, the appellant in Supreme Court, was accused number 2. Lahu Patil, accused number 3. And Devba, approver, was accused number 4. They were accused of having committed murder of one Lahu Patil. The 4th accused, Devba, had turned into an approver, and on the basis of his testimony, the other co-accused were convicted. The case of the prosecution was that Bhiva Patil, one who was before the Supreme Court, had a suspicion that his wife is involved with the deceased, Lahu Patil. And as a result of that, he was harboring some grudge and he wanted to eliminate the deceased Lahu Patil, and therefore he took support and help of Devba, the approver. A plan was hatched, a conspiracy was hatched, and as a consequence of that conspiracy, the deceased was murdered. The Supreme Court, they were convicted, sentenced to life. The High Court confirmed that sentence of Bhiva Patil. They went to the Supreme Court, and in the Supreme Court said that approver's testimony must be corroborated in material particulars qua each accused. So what it says is, it is not sufficient. Let me tell you, it is not sufficient that there is material corroboration qua only some of the accused. And as far as the rest of the accused, there is no corroboration or little corroboration. That's not acceptable. Supreme Court says that if there are multiple accused who are involved, suppose A, B, C, D, E are involved. A is the principal offender, B is the principal offender, C is also principal offender. Role of D is little bit small, E is the approver. Now suppose there is corroboration in respect of testimony of the approver qua the role of A, B, C. Though there is no specific corroboration qua role of D, Supreme Court said nothing doing. A presumption cannot be drawn that merely because there is corroboration qua the principal offenders in material particulars, it means that there is no requirement of any corroboration qua somebody who's got a lesser role. The law is after 1963 that there has to be corroboration in material particulars and it has to be qua each of the accused. Therefore, on reading of these judgments and on the reading of the provisions of section 306, 307 and 308 CRPC, what emerges or what legal position flows from this is that once an accomplice is granted pardon, he stands discharged as an accused and becomes a witness for the prosecution. As a necessary corollary, once the pardon is withdrawn or forfeited on the certificate given by the public prosecutor that such person has failed to comply with the condition on which the pardon was granted to him, he is reverted back to the position of an accused and liable to be tried separately, and the evidence given by him has to be ignored in toto. It has got no bearing whatsoever. Though that accused, that approver may get an opportunity to show that he complied with the condition of pardon when he is being tried separately. So that's important. Now, another interesting case of 1989, where state of Delhi versus Jagjit Singh, where the question before the Supreme Court was, can an approver cast away his own pardon granted to him under 306 and 307 or 307? So take a situation where pardon has been granted to accused number A. After pardon is granted, accused number A realizes, no, I should not have gone against my friends. I should be with them and I don't want to be an accomplice anymore. And after grant of pardon, he writes a letter saying that I don't want to be an approver. That action of his will not let him cast away his own pardon that has been granted to him by the court under the provisions of 306 and 307 CRPC. In the case of Jagjit Singh, the Supreme Court held that the approver cannot suo motu cast away pardon granted to him until he is examined as a witness by the prosecution. The approver may have resiled from the statement made before the magistrate in the committing court and may not have complied with the condition on which pardon was granted to him. Still, the prosecution has to examine him as a witness in the trial court. It is only when the public prosecutor certifies that the approver has not complied with the conditions on which the pardon was tendered to him. In such a situation, he may be tried under section 308 CRPC not only for the offense in respect of which pardon was granted, but also in respect of other offenses. However, the approver cannot on his own cast away his own pardon after it has been allowed or granted to him under 306 or 307 of CRPC. And it is only after his examination as a witness when he does not support the prosecution, and only when the prosecutor issues a certificate under 308, the pardon could be revoked. Now, I come to an extremely important judgment, Renuka versus State of Maharashtra. Now, this was a judgment that really shook the conscience of State of Maharashtra. This was a case where brutality had no ends. And let me tell you the gory facts of this case before I discuss the law and why I disagree with the law that was being laid down in this case. Anjana Bai, the principal accused number 1, and her 2 daughters, Renuka Bai and Seema Bai, and the husband of Renuka, all were charged for the offense of having committed murders of around 9 children in the decade of 1990 for personal gains. Anjana Bai died during the trial. Renuka Bai and her sister Seema Bai were tried, sentenced, they were convicted, sentenced to death. In this case, husband of Renuka turned into an approver and he supported the case of prosecution. Now, what was the modus operandi? In 1990, Renuka Bai, along with her son Ashish, had gone to a temple, and Renuka Bai, Anjana Bai, and Seema all were involved in the offenses of theft. That was their source of livelihood. So in 1992, when Renuka had gone to a temple along with her son, and she was trying to commit theft by snatching a purse from a person, she was caught in that process. On being caught, she raised hue and cry and questioned the person as to why he had caught her when she was having a child in her hands. Why will she commit theft, or why will she do something like this? After she raised hue and cry, she was allowed to go by the public who had gathered there. Renuka went back to her mother and told her what had transpired. And then they developed this criminal design where they thought that they should abduct small children below the age of 5 years, use them as their own children, commit the offense of theft, and if they get caught, mercilessly assault those children in front of public at large in order to show their innocence, in order to show why would they do something like this. People would naturally get scared. People would naturally get upset seeing that a mother is assaulting her own child. Why will she do that? Why will she do something like this? And perhaps she's not been involved in any theft, and perhaps it's a wrong accusation. And on the basis of that, they started doing these kind of activities, and they succeeded in abducting 13 children, out of which 9 were murdered by them, by brutally assaulting them when such kind of incidents were taking place, when the thefts were taking place, and when they were apprehended by the police or by the people. They would raise hue and cry, they would assault those children mercilessly, and then they would be allowed to go back home, and children unfortunately used to die because of that assault. So these women were tried and they were sentenced to death. The High Court confirmed the death sentence, the Supreme Court confirmed the death sentence. However, while confirming the death sentence, Supreme Court said something which, in my respectful submission and with utmost respect to the Supreme Court, and I believe that there is utmost sanctity to the judgments of the Supreme Court, I cannot disagree with that. However, with the law that the Supreme Court laid down in this, I have a different opinion and I beg to differ. In this case, the Supreme Court said that the approver was present when many of the murders had taken place, and it is quite possible that he must also be an active participant, and the High Court was justified in saying that the approver had not given full details of the crime. That's one. Thereafter, the Honorable Supreme Court said the court itself has an inherent powers to proceed against the approver in case he is willfully suppressing material facts or is giving false evidence. And then further, the Honorable Supreme Court said the approver's evidence is fully corroborated by other items of evidence, and reliance was placed upon it, and conviction and the order of conviction and sentence was upheld. Those 2 ladies still await the execution of death sentence. However, the point today that I'm trying to make is, in this judgment, the Honorable Supreme Court said that the court has inherent powers to proceed against the approver in case he is willfully suppressing material facts. Now, with this proposition of law, I beg to differ, for the reason that the Code of Criminal Procedure is an exhaustive code of criminal procedure. It identifies the powers of each court. Under the CRPC, there are no inherent powers reserved for the trial court. Though such inherent powers are reserved for the High Court under Section 482 of CRPC, there is no pari materia provision qua the powers of the trial courts. That's number 1. Number 2, if you look at the scheme of Section 306 and 307, it is very clear that the code has reserved the power to the trial court to refuse pardon in a given case when the trial court feels that granting pardon will not be in the fitness of things because of the role of that accused. In such a situation, the court can refuse granting pardon to him. But after pardon is granted to an accused by the court, the ball goes into the jurisdiction of the concerned prosecutor, because it is only the concerned prosecutor who under Section 308 can issue a certificate to forfeit the pardon that has been granted to an approver on the condition that he is not making full and true disclosure. So 306 reserves the power of trial court at the time of granting pardon. 308 acknowledges the power of prosecutor after the grant of pardon to revoke the pardon, primarily because after the pardon is granted to an accused, that accused gets converted into a prosecution witness. He becomes a prosecution witness, and therefore it is the call of the prosecution when to revoke his pardon, when the prosecution feels that he is not coming out clean. Now in this case, the Honorable Supreme Court had expressed a possibility, and please read the words, the Honorable Supreme Court said it is quite possible that he must have been an active participant. On the basis of that possibility, the Honorable Supreme Court made this observation that the courts have inherent powers. However, the Honorable Supreme Court also said that the approver's evidence is fully corroborated by other items of evidence. Therefore, in my respectful submission, the trial court has got no inherent powers to revoke any pardon after the pardon has been granted to the accused under section 306 by the trial court. Now, in fact, in C.B.I. versus Ashok Kumar, the Honorable Supreme Court identified, and the Honorable Supreme Court in fact reiterated that the trial court has powers under 306 to refuse to grant pardon to an accused in a given case. The Supreme Court said in this judgment that the court granting pardon cannot be a mute spectator, and it is not bound to accept the proposal of pardon without judicious application of mind. The court that acts to tender pardon must, of course, know the nature of the evidence the person seeking conditional pardon is likely to give, the nature of his complicity, the degree of his culpability in relation to the offense and in relation to the co-accused. And therefore, the court cannot be a mute spectator. While the court is hearing an application of pardon, the court has to apply its mind judiciously, and the court may refuse to grant a pardon. Though the prosecution is requesting, the investigating agency is requesting that pardon may be granted, the court has its rights to refuse the pardon when the court feels that granting pardon would not be in the interest of justice. In fact, let us take an example. A, B, C, D are, again, I'm sorry, I have just been giving examples of A, B, C, D. Let me give you an example of X, Y, Z today. Now, so X, Y, Z are involved in an offense. Z is husband of one. Z hires X and Y to murder one, who is the wife of Z. X and Y accordingly murder one. And then they are arrested. They, in their confession before the police, say that Z is also involved. Z had given us the supari. Accordingly, Z is also arrested. Now, it is at the behest and at the instance of Z that X and Y have murdered one. Now, in such a situation, suppose the prosecution moves an application to grant pardon to Z in order to throw light on the events that may have transpired during the murder. The prosecution may do that. However, the trial court can refuse to grant pardon to such an accused because he is morally and he is principally more involved in this offense, because it is at his instance that X and Y have committed the murder. Therefore, in C.B.I. versus Ashok Kumar, the Supreme Court said that the court cannot be a mute spectator and court can exercise its jurisdiction in refusing to grant pardon in a particular case. Now, how a defense lawyer can impeach the creditworthiness of an approver. So there are a few instances. The first is to show that he is an unreliable witness. Let me tell you, the Supreme Court in 1957 had evolved this two-test doctrine that he has to be a reliable witness and there has to be material corroboration. Now, if as a defense lawyer, it should be your endeavor to show that the testimony or the version of the approver is not as a reliable witness. It is very important for the trial court, therefore, to find out that there is nothing inherently improbable in the evidence given by the approver. If the story he relates involves him in the crime and appears intrinsically to be a natural and probable catalogue of events that has taken place, only then the court can consider the test of reliability to be complied with. Now, let me give you an example. In case of dacoity or robbery, by reliability, it means that on the touchstone of naturalness, the story of approver sounds to be improbable, appears to be improbable, and appears to be incoherent. So let us take an example of robbery or dacoity. There are 6 persons involved in the offense. The accused number 6 is turned into an approver. Now, as a defense lawyer before the trial court or before the high court or before the Supreme Court, our endeavor should be as a trial court lawyer to bring on record the unreliable aspects. That is, suppose the approver is not connected by blood or thick friendship ties with accused number 1 to 5. Suppose accused number 6 and accused number 1 to 5 are having just casual acquaintances. They do not even reside in the same village or same city. Nothing to show on record that approver would stake his life and future prospects for the co-accused persons. if it is come on record that there was no prior arrangement between the approver and the co-accused about the sharing of the crime amount, then this would naturally show that the relationship between the approver and the co-accused persons was not such as normally would prompt the approver to participate in the crime. They were not thick of friends. There was no blood relationship. There was casual acquaintance. There was no arrangement as to how the crime amount is to be shared. There's nothing to show that he would stake his life and future and career for these persons. And if it is come on record already, and if it is not come on record, as a defense lawyer, one must try to cross-examine the approver to bring such kind of aspects. I'm just giving an example. Such kind of aspects on record in order to establish the concept of unreliability. Because if these aspects are on record, the natural conduct on his part when he was asked to be a party to the offense at the time of the alleged conspiracy would be to disclaim all interest therein, or in any case to keep mum, go back at his house and do not fall for any efforts that they may make to involve him, to rope him in. His stand that he was a willing party, despite all the facts like this that you have brought on record, that he was a willing party and still participated in the robbery, becomes suspect. And therefore, from his own showing, he is an unreliable witness. Another way how you can, our defense lawyer can discredit a approver is to prove contradictions and omissions from his previous statements. So an approver, before he becomes an approver, his statements are recorded. Either it could be recorded under 161 CRPC, it could be recorded under 164 CRPC. So we will have to bring on record all the contradictions qua his earlier statements and qua his earlier statements and qua what he's saying now in court on oath, and all those material omissions which would amount to contradictions under section 162 of CRPC. So we have to show that he is unreliable witness on the basis of the fitness of things that he is stating on oath. It does not sound to be probable, natural, coherent. We have to bring on record the contradictions and omissions by making reference to section 145 of the Evidence Act, by making reference to section 161 of CRPC, 162 of CRPC. In fact, I have spoken at length on the last occasion as to how to bring contradictions and omissions on record. I will not reiterate, but that is one of the aspects to discredit a witness. Third, to expose the approver by referring to his conduct in respect of the incident. Now, conduct of an accused must have nexus with the crime committed. It must form part of the evidence as regards his conduct either preceding, during, or after the commission of the offense as envisaged under section 8 of the Evidence Act. In case of conduct, in this case, one has to show that the conduct is unnatural prior to the offense, during the offense, after the offense. So if we are able to bring on record all this conduct of this approver as to that this conduct does not inspire confidence, that this conduct does not befit in the course of things that are being stated on record or on oath by the approver, then that is one of the ways how you can impeach the credibility of such an approver. And lastly, to bring on record that the approver was induced to become an approver. See, normally there is always an element of inducement and involved when an accused wants to become an approver, and the inducement is that he would be allowed to go scot-free. However, apart from that, you can bring on record if there is threatening being done to him, if he's being pressurized, if he's being offered any remuneration, if he's being offered any money, any inducements, any allurements, if there are any external forces working upon him while he agreed to be an approver. So all these things you can bring on record in order to impeach his credibility or to discard him as a credible witness. To reiterate, an approver itself is a weak witness. His evidence is stained, and the court has to be circumspect while dealing with an evidence of such an approver. However, in extreme circumstances, the court can rely upon such evidence on the basis of reliability and on the basis of corroboration. However, as a defense lawyer, it is your duty to establish all that is in his evidence which would show that he is unreliable, which would point out his conduct which is unnatural, which would bring on record any aspect of inducement, and also all his contradictions, omissions from his in comparison to his earlier and previous statements, which will help to demolish his version. So that is it with the law of approver. I hope I have been able to elucidate the law of approver. You were a fantastic audience. Thank you very much. And I will leave with one thought. I'm sure, I'm aware that the pandemic has troubled all of us, but I have sincere faith in humanity. I have sincere faith in the cause of our Indian culture, and I'm sure as a country we will come out stronger, healthier, and more resolute. Thank you very much.
Oh, thank you so much, sir. On behalf of Law Chamber of Siddharth Murarka and the Law Club, I would like to thank you for sharing your vast knowledge on approval. Indeed, it was a very good session. I'm sure the participants would have loved this session, and sir, we would like to have more session by you in coming future.
Yes, thank you. Thank you. Thank you, Devendra.
Thank you, sir. Thank you.
Thank you very much.